This case starts off like a routine plea hearing, but don't let that fool you. Ashley Hernandez is facing a state jail felony for drug possession, and right from the beginning, the court is locking in her rights, her waivers, and her plea. But here's where it gets interesting. She's asking for leniency, treatment, and a second chance, while the judge is quietly building a case for accountability. The real question is, will this end in rehabilitation, or is the court about to shut that down completely? Stay with us because what unfolds next takes a sharp turn.
We're going to go on the record now. Court is calling 2023 CR 9542W, State of Texas versus Ashley Marie Hernandez. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Attorney Bill Simmons for defense.
And are you Miss Ashley Hernandez?
Yes, ma'am.
Counsel, you received all the discovery. Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Hernandez, did you review the document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
All right, who's in the, off the record, who's that back there?
It's my client.
Oh, sure. Okay, no problem. Oh, no problem. All right, did you understand, we're back on the record, did you understand that you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not this case should be held over for trial?
Yes, ma'am.
Did you understand your attorney has certain rights, namely 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Showing you what's entitled Application for Deferred Adjudication. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Showing you the information. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the information?
Yes, Your Honor.
State, are you proceeding on the information as presented?
Yes, Judge.
Going to show you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, I did.
Did you understand you're charged with possession?
This is a critical moment that often gets overlooked. The judge is laying out the full weight of the charge, state jail felony with up to 2 years behind bars and a $10,000 fine. And notice how carefully the court ensures she understands every right she's giving up, including a jury trial and the ability to confront witnesses. That's not just procedure, that's protection. Once she agrees, there's no easy way back. So here's a question for you. Do you think most defendants fully grasp what they're signing away in moments like this?
Possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
My opinion, she does, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
In my opinion, she is and was, Your Honor.
Ms. Hernandez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am, I did.
According to the plea bargain agreement, there's to be a $200 fine, probated. The state will take in consideration the following cases: NIMAG number 734-824, 706-758, 706-759. They're recommending deferred adjudication, and they're asking for a drug court evaluation. So just so you're aware, drug court is full, but we will ask for the evaluation, but you may not get in. You understand?
Yes, ma'am.
All right, did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court.
Now here's where things start to shift. The state is recommending deferred adjudication, which on paper is a huge opportunity. It means no conviction if she successfully completes probation. But listen closely, there are conditions, evaluations, community service, and strict compliance. And even then, the judge makes it clear, nothing is guaranteed. Deferred adjudication can flip into a full sentence if she slips up. So while this sounds like a second chance, it's really more like a tightrope. Do you think she's in a position to handle that kind of pressure?
Do you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement.
Yes, ma'am.
State is recommending that your deferred adjudication be for a term of 4 years. There be a TAP evaluation and 100 hours of community service restitution. Did you understand those were recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
State offer, State Exhibit 1 and all attachments.
No objection.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you and your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
And Judge, may I approach? I was
Yes.
going to look at the court admonishments. I believe I forgot to write in possession of controlled substance in the full body. I think it's a blank space. I should put it in.
Let me see. All right, you may want to look in there. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, ma'am.
Counsel, are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We would just pray that the court follow the plea agreement.
All right, Ms. Hernandez, when's the last time you were employed?
Like 4 months ago.
Doing what?
My dad has a lawn, he owns a lawn care.
All right, what's the name of this person you were with?
Like working.
No,
Jack
and the police report.
Oh, some homeless guy that I was out there with.
All right, just off the record for a moment. So on this, instead of putting this in here, if you just say that he was in, yeah. Thank you. All right, we're back on the record.
It was just some random guy. I was homeless at the time. It was just some guy up the street, user.
All right. Do you have any children?
Yes, ma'am.
How old are they?
I have a 17-year-old, a set of twins that are 14, and a 13-year-old.
And where are they?
They've been adopted. They've been out of my life for, well, I'm gonna say pretty much all my.
This is where the emotional weight hits hard. 10 years of heroin use, children no longer in her life, and homelessness. This isn't just a legal case anymore, it's a life unraveling in real time. But the judge isn't just listening, she's checking, challenging inconsistencies, and calling out what doesn't add up. That moment about being almost a year clean, completely dismantled. And it raises a bigger issue. In court, credibility is everything. If the judge doesn't believe you, everything else starts to fall apart. Do you think the judge is being too harsh, or just realistic?
Okay, how often were you using?
I was using for at least 10 years.
Okay,
I've been clean for almost a year already. I was using heroin.
Well, it can't be almost a year because we're still in
barely going off like.
all right, because we're still in 2023. Am I right in that?
Yes, ma'am.
And this offense was April 3rd, 2023. So you haven't been clean for a year.
That's going to, it's going on a year, right? I mean, a couple months, I guess.
Okay. All right, this is what the court is going to do. Court is going to sentence you to a $200 fine that'll be probated. I'm going to want a TAP evaluation. Follow all TAP recommendations. Sorry. Follow TAP recommendations. If they recommend inpatient treatment, she needs to go to inpatient treatment. And that's to be followed by felony drug court, 4 years deferred adjudication, 150 hours of community service restitution. The TAP evaluation is to take place in custody. Proof of employment within 45 days of release. No employment as a home health care provider or with minors. Regular reporting by Zoom or in person. We'll do the UA hotline until further notice. Field visits 1 time per month until further notice. Probation, is there anything else she needs?
No, Your Honor.
All right, is there anything else you need from the court to be successful?
Judge, she has a job, I believe, outside. But the real question is just, do we know about how long the TAP evaluations are taking right about now?
Probation, how long is TAP? 2 weeks.
Would the court consider, well, I don't know, would you like to explain to the court why you feel like you need to be?
Honestly, because me being on sober living and my dad being back in my life, he's helping me get back into church, and I wanted to be a part of this ritual, this what is it called? It's like a woman barrier, and I wanted to go on this retreat so I can cleanse myself and actually.
Okay, let me ask you this. This retreat, does that retreat happen every year?
No, it's just like one time. It's just one time. Like I
Like they only have it one time forever?
No, ma'am, but honestly, this is what I signed up for. So I've been living with this lady and I told her I honestly would be there for her. Like, and she's.
All
my
right, so
support. I'm not.
here's
lying.
the thing. I've read the police report.
Yes, ma'am.
There's heroin and everything else going on with you.
Yes, ma'am.
So no, the answer is going to be no from the court. You're going to do a TAP evaluation in custody. And if they recommend inpatient treatment, you're going into inpatient treatment. Do you understand?
Yes, ma'am.
All right. Have you been to prison before?
Yes, ma'am.
For what?
For intent to deliver.
All right. And so felony drug court is not going to accept her. So we can take felony drug court off the list and do a gang evaluation. What is the tattoo on your chest about?
Jesse. It's my ex-boyfriend. He passed away. I put his name. It's Jesse. That's it.
Okay. We're going to do a gang evaluation, and we're going to remove felony drug court because with the intent to deliver, felony drug court is not going to accept her. You understand? Okay, here's the thing. You have a drug problem.
I
That's why
understand.
we're here.
I understand, ma'am.
And you've been to prison before, and so you still haven't gotten your life together. State has offered you deferred. People want
I'm trying right now.
to write their own program. Guess what? If you could write your own program, we wouldn't even be here because you would have written your program and you would have been successful, and you wouldn't have been with some random guy that you don't know and y'all using random drugs.
That was the first case, ma'am.
Showing you that's what's in the police report for this case. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it?
Yeah.
She was just having like a appeal form. She
Yes.
follows up the agreement.
All right. So here's the thing. I don't understand why I'm getting pushed back in the attitude. Here's the thing. If you want to, you can withdraw your plea In exchange, I will send you to the state jail facility. You can do your time, you can get out, and you can again try to write your own program. You understand? All right, so the trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, good luck to you.
In the end, the court chooses structured accountability over flexibility. Ashley gets deferred adjudication, but under strict conditions, custody evaluation, possible inpatient treatment, and no shortcuts. The judge makes one thing crystal clear. Recovery isn't on the defendant's terms. It's on the court's. This case highlights the balance courts tried to strike between second chances and public safety and how quickly leniency can turn into consequences if trust is broken. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.